Hi, my name's Ryan Fowler, and today we're going to talk about limited liability concepts as they relate to business entities. So limited liability means you are not responsible for a business's debts, and generally the business is not responsible for your personal debts. It's like you and your business are two unrelated people, almost like your business is a distinct person and you're a distinct person. And unless a creditor convinces a judge that the entity is what's called your alter ego, it'll be kept separate. But if there is an alter ego ruling, then you're not going to get that limited liability. So we're going to discuss what the alter ego is and how to prevent that from happening in this video. So let's talk about liability of management. Now, let's say you have a corporation. The shareholders are with a limited partnership. The limited partners or people that just put in capital and they don't manage, they're going to have limited liability for business debts. What about the managers that actually manage the business? Well, even though they are not liable for business debts, they are still liable for their own torturous acts or acts of bad faith or anything like that, gross negligence. Even if they're acting on behalf of the company, they can still be sued if they have torturous acts or something like that. And that's why you have directors and officers insurance that you can buy to protect in case they do something bad that gets them sued. But they do have limited liability for business debts otherwise if they didn't do anything wrong. Also, generally, unless you're dealing with a general partnership, one partner or manager is not liable for someone else's mistake. Although they may be liable for the company will be liable for mistakes of employees and occasionally maybe their boss as well if he wasn't supervising well. So let's talk about alter ego arguments. Not all of these arguments that are used, these are the different types of arguments a creditor will use to try and disregard your business entity so that they can go after your personal assets for business debts. Not all of these arguments apply to every entity. Some of these really only apply to corporations, and then some apply to all entities. I'll tell you which is which. So the first alter ego argument is called instrumentality or domination. This really only applies to corporations. A corporation is supposed to have a three-tiered management structure. You have shareholders that vote in the board of directors, and the board of directors handle the strategic decisions for the company, and then the day-to-day operations are handled by the corporate officers. If you have one person that does all of those roles, or they can show that one person is basically controlling the whole company, then they say, well, you're using that as your personal instrument or you're dominating the company. That is grounds with the corporation for an alter ego argument and to pierce the veil. With a limited liability company or a limited partner that has one general partner, it's not an issue. Those companies are meant to have only one person, or they're designed so that only one person can manage it, and you still get limited liability. But with corporations that have a three-tier management structure, it can be an issue. The worst problem I see is a lot of one-man S corporations where there's just one guy and he handles everything. Yeah, you'll get your tax savings with that S corporation, but if someone sues you, they may try and use this argument to try and pierce your S corporation. It might be successful, it may not. S corps are supposed to be small businesses, but it's a vulnerability, and this is one reason it's better to use an LLC tax as an S corporation instead of an S corporation outright. The next argument is improper purpose, and that's where you're using a business entity for something that should not be used for. And if you use it to perpetrate fraud or some type of injustice. Also, if you use a business entity to protect or hold strictly personal assets, that is also improper purpose. And this can apply to any type of entity, limited liability company, LP, corporation, whatever. There's a quote from a court there. They're saying, well, asset protection not illegal, but if you take entities such a corporation, LLC, whatnot, put personal assets in it just to shield it from creditors, we are going to say this entity is the alter ego of the individual debtor, and we're going to disregard it to prevent injustice. So that is a court example of improper purpose for a business entity. Now, there are a few states where the statute seems to authorize you to use an LLC or other business entity for a non-business purpose. I would still exercise caution in those states because you can never tell how a judge is going to interpret that statute. And there's a fair amount of case law in other states saying business entities should have a business purpose. So you got to be careful, but it may be a little more solid using an LLC to hold a personal asset if the state says, well, you can use it for any purpose and it doesn't specify business purpose only, but be careful regardless. Also, you want to be careful of commingling. Commingling is where you use your business assets to pay your personal debts. For example, you use your corporate account to pay your personal car payment or your house payment or to buy groceries. That's a big no-no. That's also improper purpose or improper use of business funds. You want to take out profits, pay yourself profits, and then use those profits after you've paid yourself from the company to pay for personal expenses. That's the proper way to do things. Commingling is not, and it can lead to your limited liability entity losing its limited liability and your asset protection plan just falling apart. Another thing that needs to be there when you a creditor tries to pierce your LLC or other limited liability entity is proximate cause. That means they need to have a reason to sue the LLC or the corporation or any other entity. If you have a corporation that engages in business, but the person that's suing you did not do business with this corporation, and the the reason they're suing you has nothing to do with the fact that you have this business entity, well, guess what? They cannot sue the business entity. So they need to have proximate cause, and they need to have some type of claim saying, this business entity wronged me, or this business entity owes me a debt. That's the reason I'm suing it, or that's the reason I'm trying to collect against its assets. You got to have proximate cause. Another thing I just want to emphasize is what some people will do is they'll set up entities and say, well, I don't own it, I'm not connected to it, and they try to, this isn't exactly has to do with proximate cause, but it kind of does in a way. Just because you don't own an entity doesn't mean you can't be tied to it. There have been cases where someone doesn't own a corporation, but they're using the corporation for their own business benefit. I guess this can be improper purpose too. And a court has says, well, technically you're not the owner, but the way the company's being run, you really are the owner, and because you're doing some other stuff that allows us to pierce the veil, we're going to pierce the veil of that entity and get all the assets inside for your debt. So don't think that having bearer shares or technically not owning a company means that assets in those companies will never be grabbed. There's a court case, a Nevada court case, LFC Marketing versus Loomis. You can look up, you can Google that, and I believe it'll come up if you Google it. So just not owning it doesn't mean you're safe from alter ego argument. If a company doesn't have enough capital to meet its anticipated debts, it can be pierced under the theory of undercapitalization. Now, you have to capitalize your company enough to meet its anticipated debts. So if you sign some type of lease and you don't put enough capital in the company to pay for the lease, then if the lessor sues your company, they could go after you personally saying, well, listen, we thought this corporation was solvent. It wasn't. And they undercapitalized it. If someone sues you and it's not a debt you were anticipating, they sue you for some type of tort and there's not enough money in there to pay it, well, that's not an anticipated debt. So the undercapitalization theory should not be available to the creditor in that instance. But anytime you enter in a business arrangement, don't knowingly enter into a business arrangement knowing you don't have enough capital in the company to pay for this debt that you're going to enter into. That can lead to a veil piercing. Reverse piercing. Normal veil piercing is there's a business debt or someone's suing the business and they try and get assets of the owners and try and disregard that limited liability shield. Reverse piercing goes the other way. They're suing the owners of the company and they're trying to get assets in the business. Reverse piercing is actually harder to do than regular veil piercing. There are a lot of problems with it, especially if there's multiple shareholders or owners of the company, and if the company has other creditors that would be harmed and the company now can't pay its debts to its normal creditors because of reverse pierce, usually then a reverse pierce will not be allowed. I have a video on charging order protection that covers reverse piercing in more detail. And that is our today's video, and I hope you found it useful. Thanks.